level of generality, but you also have it relying on inadmissible facts. And in fact, if you look at the
inadmissible facts,
unsubmitted and inadmissible factual record, the court found that there was a factual dispute and looked, for example, at anonymous witness, and I believe it's at page ER 18, where the court cites to the anonymous witness that no party submitted a declaration, there was not a deposition,
yes.
But the court found that those statements, which were unsworn hearsay, as well as the Board of Police Commissioners report, which was based upon a different legal issue, namely whether there was a policy violation, created disputed facts. And yes, Your Honor.
I was going to say yes, and I think you briefed that very well, those evidentiary issues. But let me just check to see if my colleagues have questions about the evidentiary issues before we take a bunch of your time on that. I don't know. How much time did you say you wanted to reserve?
I was going to hold 2 minutes, but
go right ahead.
Now, so
you've got 3. Go right ahead.
So I think unless you have questions, I'll submit. I think the issue that we've addressed in very detail is whether it's clearly established, and I believe we're in agreement as far as the legal issue, and the fact that the question becomes one of did the court err in defining it too high of a level. Isavea is the leading authority on this. It was decided roughly a year before this case. Every reasonable officer would have relied on that, which if you take the Isavea case and you literally do a name change of the briefing and the Court of Appeal opinion, it is the same legal issue. The trial court denied summary judgment, 2 officers losing in hand-to-hand combat. One of the officers begins to lose consciousness. At that point, yells, "Shoot him." That's no further warnings, no further announcement that there's going to be lethal force utilized. And at that point, the suspect
there was an announcement, "Shoot him."
Shoot him was used, not we're going to stop or we're going to shoot. And there was a similar announcement from Agdeppa where you can hear something on the audio that confirms that something is said.
Does he anywhere in the record indicate that I didn't see it, and this is truly a question. I didn't see anywhere where Mr. Officer Agdeppa says that he gave warning that he was going to use lethal force. I saw words to the effect of stop.
Yes, he said he yelled something, but he doesn't recall specifically. He was still somewhat dazed.
Right. Thank you. When you come back, we'll put 2 minutes on the clock.
Thank you.
Thank you for your patience with the questioning. I can't see opposing counsel. There he is. Okay, go right ahead.
Good morning, may it please the court. I'm Ed Lyman on behalf of the decedent's mother, Paulette Smith. And just touching on that point about Isavea, it's clearly a distinguishable case and facts in the sense that here there weren't any warnings given. So using that as a comparison
go right ahead.
I mean, the comparison to Isavea is sort of beside the point for me because it seems there Mr. Agdeppa is sort of trying to say not only was the law not clearly established, but that it was clearly established in his favor. I don't think he needs that. So I guess the question for you is, what is the clearly established law showing that this was a constitutional violation, recognizing what the Supreme Court has said about the level of specificity we need to employ when doing this analysis?
Well, if we look at the case of Tennessee versus Garner, for example, there's genuine disputes of facts concerning whether there was any kind of imminent threat posed to Officer Agdeppa, Officer Rodriguez, or anybody else for that matter in this enclosed environment. And you know, the district court
disagree with you about that, counsel. If we disagree with you about that, we've got the audio and the video, and if we disagree with you on that point about whether there's a disputed fact about whether he represented a imminent threat, then what happens?
If you disagree with me about that, if there's an imminent threat, well, we're still looking at the use of lethal force, and there's 5 shots that occur. And we see in the Officer Agdeppa's statements and testimony that he had 5 opportunities here and deployed 5 rounds of lethal force of a 9mm shell. And it's disputed there in terms of what Mr. Dorsey's body position was in, for example, and the angle and the trajectory of these bullets. And then we see Officer Agdeppa saying that he had time to stop and reassess the situation between each round that he had fired. So each opportunity was another one to reassess and give another warning before
You had an
redeploying.
opportunity to reassess between the rounds?
Yes.
To my ear, the rounds sound like they're really rapid in succession.
And I think that's definitely what's confusing in terms of Officer Agdeppa's credibility, and that's what we see the district court's findings there, and why there is a dispute of genuine issues there.
And the dispute is that there's testimony that he had opportunity to reflect between the shots. Is that your position?
That's not necessarily the only dispute, but it speaks to the broader point of the district court's findings that there's credibility issues there. There's different versions of events. There's different witnesses saying different things. And
that's pretty common that we have, especially after a very traumatic event, that the witnesses are going to recall that differently. District courts see that all the time, and we even on appeal we see that all the time. So that can't be the answer, at least on my scorecard. I think there's a very well articulated argument, and opposing counsel has just made it here again today repeatedly as he very patiently entertained these questions, that there's a tendency to define the law at too high a level of generality, which is why I've asked him, and now I'll ask you to focus on the more specific case law requiring warning prior. You've gone away. Are you there?
oh, I'm here. Yeah.
Disappeared.
So yeah.
All right, so my question is, could you speak to that? He's making the argument that there's, even though we've got case law talking about or requiring the use of warning prior to resorting to the use of lethal force, if practicable, and he's relying on the if practicable part of that holding. Could you speak to that? Is that sufficiently specific or too general? What is it?
Sure. In terms of it's in our brief, we have Diorly, for example, we showed and distinguished that. Then Rose versus City of Sacramento, we have very similar facts there in that case, in the use of deadly force.
To be clear, my question is, would any officer know that before using lethal force, he or she is required to give a warning that lethal force was going to be used, if practicable? Would any reasonable officer know that?
Yes, Judge Kristen, that's an excellent question. It's in the Coast Training Manual for the LAPD. It's part of the manual, and I believe that's in the record as well. And
I think it is too. I think it is too. So here's the problem with this case, and I keep trying to get people to focus on this very sliver of an issue. It is in the record, but it still begs the question, because in this case, it's very unusual. Officer Agdeppa's declaration indicates that he did give warning. And then we can hear on the audio, it sounds like someone says stop. That may be a different word that's given. But what if we were to decide that he did give warning? There's nothing in the record where he claims that he gave warning that he was going to use lethal force. What do we do with that?
Right. Well, I mean, obviously on the interlocutory appeal of the issue of qualified immunity, we're confined to all the findings in favor of the plaintiff. In terms of factual determinations made below. So we're confined to that, and that would have to be in my client's favor in terms of any kind of
so let's look at it in your client's favor. In your client's favor, the undisputed facts would be that, for my hypothetical, if we decide that the circumstances allowed the use of deadly force because they did, then in this circumstance, the undisputed evidence, I think, shows that a warning was given and we can't tell what it was. Is that right?
I'm not sure I understand the hypothetical is.
In other words, I don't see anywhere in the record where Officer Agdeppa claims to have warned that lethal force was going to be used. Did he have to do that?
Well, I mean, he would have to in this specific situation because there was an element of time and separation. I mean, this occurred over about 14 minutes when we see the beginning of the body-worn camera and all the footage. So, and that, if we look at the California Supreme Court and Yount and its progeny, we start to see this development of separating time and giving it repeated warnings over time and different opportunities to de-escalate or use different tactics.
Officers here used a lot of different tactics, non-lethal force, as you said, for about 13 minutes, I think, we're tasing all kinds of, and that wasn't working. And so when we get right down to it, one officer was down, she was being pummeled. I think that's undisputed. And Officer Agdeppa's testimony is that he thought the next blow could take her life. And so if my hypothetical is that he was justified in using lethal force, I'm trying to get at what warning was required to be given there. What is your answer to that? What's your position on that?
I mean, he would have to give the warning that he's about to fire and use lethal force. I'm about to shoot.
And then the question was that law clearly established? That's the question. So Gonzalez says, the en banc court says a warning must be given before deadly force is employed whenever practicable. Is that, so you have, in order for you to win on that theory, which is a lethal force warning should have been given before the shots were fired,